You are listening to the Julie Parker Practice Success Podcast, where you discover management insights and strategies for your successful dental practice. There are also interviews with key people in the industry who have advice and services to help you and your team achieve great success. Welcome to this week's episode of the Julie Parker Practice Success Podcast. And we gloriously are visited by Burke Associates, our resident legal team that advise us on all things legal in terms of dental practices. And today we have Solicitor and Principal, one of the principals of Burke Associates, Rosy Roberts. She's come back for your second time, is it, Rosie?
Yes, it is. Thank you so much for having me today, Julie. It's lovely to be back talking to all your listeners.
Fantastic. It's thrilling to have you back again. It feels like a long time since I last had a legal discussion with you. And today's going to be really meaty and juicy, isn't it? We're going to be talking about disputes and litigation. This all sounds very deep and potentially, anxious and anxiety-ridden.
That is right, Julie. That's exactly right. And I really thought this might be a bit of a timely topic for your listeners, given the effect we've seen with COVID and what that's had on businesses, and some have been left really struggling. And then it can also mean a time where there's been really unreasonable demands maybe that are made from business partners or external parties. So there's a lot of different ways that this topic can come about, and I think I really wanted to sort of debunk those myths for you today and for your listeners and give them a bit of insight and hopefully reduce that stress.
And that's what it's about, isn't it? It's recognising that it's there, but not spending your waking hours worried about potential litigation and disputes going on, and doing whatever you can to avoid those sort of things, which, it can be a bit of a mindset thing as well, can't it?
Very true, Julie. And I'll go through that today. I'll start at the beginning. I'll talk about what a dispute is, litigation, ways to avoid it, and those sorts of things. So I might jump in if you don't mind.
Please.
And start away. So look, to start from the very beginning, no one wants to often be in a place, whether it's as an individual or with your practice, you don't want to be involved in a dispute. And it really is associated with this sort of great level of stress. And so I really hope that today I can shed some light on the processes and explain some of those terms, which will help your listeners. So I want to start at the beginning with this idea of disputes and then litigation and these terms and what they mean. So a dispute is really defined as a disagreement between two parties. Think of it as simply as that. And it's where those parties are unable to resolve their disagreement between themselves or with the assistance of legal practitioners. They may then decide to commence litigation. Now, litigation is actually this is defined as the formal process of seeking a resolution through the court system. So it's essentially a means by one party can attempt to enforce or defend its legal rights against another party, and then the matter is to be determined by a judge or a judicial officer. Now, I guess there's no two people are the same, no dispute is the same. Parties can vary, so you can have disputes between two individuals, between a business and an individual, or between two businesses. The type of dispute, there can be, for example, a contract that may have been alleged to have been breached, director or shareholder disputes within a business. You've got employees or contractor issues, debt recovery. These are just some of the few examples that I think might affect your listeners and might have come across them. And then finally, it's the court or tribunal that's best placed to deal with the dispute. So each state has a hierarchy of courts, and then you've got the federal jurisdiction leading up to the High Court as well. So I do think it's really important that parties understand at an early stage what their rights are in any dispute. And obviously a lawyer can assist in identifying those legal rights, but our role is often to also guide our clients in a dispute. We sort of engage in strategy. You're looking at risk tolerance. You're weighing up advantages and disadvantages in engaging in a dispute, taking steps to resolve that, maybe making the decision to commence litigation, and then obviously navigating the court or tribunal system to an end result. Now, an example of this is you might be considering a claim against a party which is available to you, but say time runs away from you. there are limitation periods to bring some claims in the courts. And so really, again, that advice at that early stage so that you're aware of any time limits is really crucial. So let's start with a disagreement between two parties. If you're able to do so, resolving a dispute is in all parties' best interests. And it's important to know that negotiations to resolve a dispute can occur at any point. Even if litigation has been commenced and you're going through that court process, there are opportunities the whole way along that a matter can be resolved. It doesn't mean that once you've commenced litigation, it has to proceed all the way to a trial or a final hearing. Most matters, maybe 95% of them, settle along the way before trial, or as we say, on the steps of the court. So just as you're about to go in.
Well, that's encouraging. 95% actually don't get to the point where the court is making that decision. It is actually somehow mediated or facilitated process prior to that. On the court steps, that's so funny. It feels like you go, do we go into the courtroom or do we go off for coffee?
Yes, it is often that last step of a trial and actually jumping into that people go, okay, let's try. And everyone does. Every party tries to the best of their ability to settle a dispute. It is only those that have really not gotten to that stage and aren't able to do that then having a judge make a determination and they feel that may be more appropriate. It's a huge strategy decision with litigation and continuous thought process all the way up to that. So as you said, Julie, there are a number of ways, strategies and processes that parties can use in an attempt to resolve it without getting to that point of a judge making determination. And sort of the umbrella term for this is alternative dispute resolution. And so that umbrella term includes processes such as the negotiation, mediation, there's a term called arbitration, and then other expert determination as well.
I've heard of arbitration. So arbitration hasn't gone through the courts yet.
Arbitration, I'll tell you what that is. So that is when the matter is referred to a neutral third party, or what's called an arbitrator, but it is for determination. So they can make final and interim awards, and it is conducted in a manner that's similar to litigation, but the hearing and determination are private and confidential. So in that instance, it's more like a mediation position, not so much in the court process. So it's not in a state-run court, it is a private determination, but someone does make a decision in that. Whereas you have mediation, which is the process where parties can discuss the issues in dispute with the assistance of a mediator to try and resolve it. But this mediator, they're an independent person and they're often specialised in the type of proceeding, but they don't make any determinations. Their role is really to assist and guide the parties towards a resolution. And again, it is then again a confidential process. So anything discussed in a mediation can't then be used by a party at court at a later date.
Okay, so they can be quite free with their thoughts and feelings and not be fearful that they're then providing evidence for their court case later on.
Very much so. And the mediator is, as that person that's very specialised in the dispute, they are able to really assist as another independent person to give the party something to think about, to say, what about this option? Have you thought about this? And to give them an indication of going, well, if this went to court, it might turn out like this, or it may go around down this path. It's really another perspective that a party may not have heard before and can take from that and try and consider further if there is any option for resolution. And we see that they really can help parties kind of step through that. It brings more into focus the cost of moving forward to litigation. You're really looking at your the risk level and strategies and the advantages and disadvantages of proceeding any further at that stage. Mm-hmm. But mediation can be done at any point. It can be done prior to the commencement of litigation if parties are in a dispute, and they may be suggested that let's have a mediation, let's have a private mediation, and try and resolve it before we get to the court steps, as it were. So then the other option is this expert determination, and that usually is used to determine sort of a specific point in a dispute. As I was saying with mediation, the terms in it, you may hear these terms called settlement conference or round table conference or without prejudice discussions. They're all a similar type of mediation, and they're all terms used under this umbrella alternative dispute resolution that are options for parties to try and resolve a dispute. So if it's not already obvious, the advantages of using an alternative dispute resolution process is that it can ultimately save parties time, money, and the stress of court proceedings.
And so if two parties are at loggerheads and they can't get past their own dispute themselves, to gain access to professional mediators, do they do that off their own back? Can they just go to a lawyer and you guys have a list of mediators that they can utilise? How do they access that information, that next step?
Yeah, a lawyer can really assist with that. We have a number of mediators that are, and a mediator can be someone that is sort of independent, and there's a specialised training program for mediators. So there's an accredited training system for them, and mediators that we use within that. There are also barristers that have been trained as mediators as well. So there's different levels of them. There's a lot around that are able to assist in resolving disputes. There are different panels that may be used of preferred mediators. So there's also authorities such as the Dispute Settlement Centre of Victoria, and they may have a list of preferred mediators that they use, and they can organise and set up parties to be able to utilise the mediators' services.
Great. Is that a shared cost? 50% each party has a shared cost?
Usually it is, yeah. Usually it's the cost of the mediator, and then if there's any venue, for example, that may have some costs, that's a way of, that's usually split between the parties on an equal basis.
Beautiful.
So moving on to litigation. If those processes aren't successful for any reason, and they aren't appropriate in a certain dispute, for example, the decision may be made to commence litigation. So I really want to take the scariness out of this term and just talk about facts for a moment.
I've shared with this before with some of these legal discussions that we have.
Yes. So the litigation process requires each party to appear in a court or a tribunal. They present their arguments and supporting evidence, and a judge or a judicial officer will then make a determination as to which party is successful. Now, if a party disagrees with that decision, they may also have the ability to appeal to a higher court. And as I said before, there's a hierarchy of courts and a hierarchy of appeal.
But you don't have to just be stuck with that decision. If you really want to create more bills for yourself, more stress, take more time out of your life, you can keep going further. It would be at a higher court level, not at the same level court.
That's true.
Okay.
Yes, it will definitely be at a higher level. You cannot guarantee that it is an available option for you. There are very limited grounds of appeal. So it may be on an error of law or a fact or something specific. Each court will have different, and types of dispute will have different processes for that. So you may be able to, not a guarantee, but there are certain processes for that.
But not a good enough reason just to say, but I don't like that decision.
Yes. No. But if an appeal is allowed, it is heard by a higher court and then usually more judges. So most parties will engage a lawyer, such as myself, to guide them through the process at this stage. When it gets to a commencement of a litigation through the court, they usually engage a lawyer, but it may also be necessary to engage a barrister. So a barrister is a legal practitioner as well, but they are specialised in a certain area of law and also courtroom advocacy. Now, one easy way to explain the difference that I use with my clients is to think of lawyers and barristers like a doctor and a surgeon. they work together for the client, but you have that level of expertise that is at a higher level, but you work both together for the client through the process.
Gotcha.
So to commence litigation, one party would have to prepare some court documents, and that's setting out what their claim is. They must also then pay a filing fee. So there is costs associated simply with just starting litigation in the courts. Those costs will depend on which court. And then the defending party, who's then received those documents, will then have to prepare documents in response. So they are saying the reason that they're defending their claim, the reason that the claim is wrong.
And the filing fees, are they like in the tens, the hundreds, the thousands? I know it's a range there, but what kind of figures are we looking at?
It is a range. We're looking, it's in the thousands to go somewhere like the Supreme Court. That would be probably 4,000 or 5,000, depending on also what list you're in, if you want it expedited, if there's some urgency to the matter. So it can vary, but it can be in the thousands just to file that document. So then, depending on the type of the disputes, there are a number of steps that the court will order that the parties must comply with. It's a bit of a time frame. It's a bit of a court saying, all right, next date you need to do this by, and the next date you need to do this by. And that includes things like discovery of documents. So that is a really important point in a litigation matter, and it's a really important point for clients, because I don't think they often realise that at that stage of litigation where you have to discover all of the documents, that means you need to disclose all of the documents in your possession that are relevant to the issues in the dispute. Now that is, you have to disclose them whether or not those documents are favourable to your position. So it is a requirement to show them all so that both parties are on equal footing, they are aware of each other's documents, and that assists their case then. There's other bits like obtaining expert witness evidence that might be required, issuing subpoenas to get further documents from other third parties, and then you get to your processes of the alternative dispute resolution. A court will often order that parties go and attend a mediation, or they go and attend other similar type of, as I said earlier, the different terms in terms of settlement conference or roundtable conference. They will order that happen up to trial. And so up to the final hearing that's determined by a judicial officer or a judge. So there is really, the courts really have a emphasis on engaging in that process and wanting to ensure that the parties have entered into this alternative dispute resolution, are trying to make really good steps to resolve the dispute without going to a trial.
And are there, I know I read in the newspaper recently that it's going to take somebody in the legal arena said it's going to take about 10 years to get through the backlog of court cases from the delays that COVID had, the impact that COVID had. Is that for, because are we talking about, are these civil disputes we're talking about? Is that the right term?
Yes, that's
my Judge Judy coming out. I watch Judge Judy. I know about the civil. What's the other one? Civil and...
well, you've got sort of your civil disputes, you've then got the criminal. So we're not talking criminal disputes. We're not talking disputes where people are being pursued by the Victoria Police and the Department of Public Prosecutions there. These are civil disputes. These are matters that where it's individual parties or businesses commencing these disputes in the court. Now the delays, I understand that the delays are in the criminal system. Gotcha. In particular, the family court as well may have some delays in that area. There's been a remerger of those courts as well, so that's changed that process quite a bit. In the civil dispute matters, there can be delays. This is where this clear timetable that the court sets out for you gives parties that ability to understand how long it may take. And you are maybe looking at up to a year, if not more, but that will depend on the complexity of the dispute, how long the trial needs to be listed for. If this is a dispute where there could be multiple witnesses or there's multiple parties and multiple experts given evidence, the likelihood of that dispute being able to be heard earlier by the court is unlikely. It's going to be pushed out. The shorter ones, if you had a trial where a judge may need to hear the matter for one day because there was only two parties and there was only limited amounts of documents, limited issues in disputes, that may be able to be heard by them at a quicker rate. So all those sorts of things really come into the court's consideration in their timetabling of those orders, and how long the trial may take and how many issues are in dispute that they need to make a decision on, basically.
Ruby, so we're not talking just a few weeks and everything gets wrapped up with a bow on top. We're talking months or years.
No. Yes, it could be, but that's where, as I said, you can settle and people can resolve the dispute at any point. There is no lock-in. You have to proceed to this lengthy dispute at all. You always have the option to negotiate with the other party, and if a resolution can be achieved, it can be achieved at any point.
Great.
So I just wanted to talk about some advantages of litigation, because there are advantages, and that is, as I just mentioned, certainty. The dispute's now before the courts, right? They have a clear timetable in which the parties must comply with certain actions. And there are consequences if a party doesn't comply and if the matter can't be resolved. And that's also the benefit of time and understanding how long the dispute may be in progress for. Parties can often feel with the negotiation process, say there's not litigation yet on foot, that negotiation with a party when it's at a dispute stage can often be quite slow. You're going back and forth and you may not end up resolving, and you may have to then commence litigation. So the commencement of litigation, if there are any concerns about delay, about parties not responding, it can be a way of bringing the matter to a front in people's minds, and going down that process keeps clients really in check with their priorities in resolving the dispute, considering the costs, looking at the risks, looking at the advantages and disadvantages of what they're trying to achieve. So it keeps all of that right at the front of clients' minds. And as we said earlier, there is an appeal option that may be available to a higher court as well. But the disadvantages: litigation, it can be long, it can be complex, and it can be expensive, and it doesn't guarantee the outcome you seek. We have to remember that litigation, it's adversarial. What we're going through by its very nature is a fight, which can be extremely stressful for some people. Now, Julie, I wanted to touch on costs with you.
That was just playing on my mind. The longer it goes, the more expensive it gets. How can you make an effective call on whether to go through the litigation or not?
Yeah, and it is a commercial decision. It's a commercial decision for clients, weighing up the benefits and looking at their risk tolerance. Are they happy to give it a shot? Are they wanting to resolve it at an early stage to get rid of that stress, and then the cost as well that associated with that? It is, the longer a process goes on, the more costs you're going to be looking to pay, both for a lawyer and a barrister to be involved as well, and other court fees and bits that come up as we progress through. But a really common statement I hear from clients is, oh, well, if I win, they'll have to pay my legal fees.
I hear that too.
Now, if you are successful in a matter, it is likely that the court may order that the opposing party pay some of your legal costs. But we need to remember, these costs are calculated by a court scale, usually. And these court scales are at a lower rate than the legal costs of any barrister or lawyer. So in the end, parties may only recover between 25 to 70% of your total legal costs if you are successful.
That is a big point to ponder. Because I imagine, for many other reasons as well, why there's a court scale in place. If it was all, guaranteed, oh, yes, they have to pay your court costs, and then your lawyer gives you an invoice for 4 times the amount, so everyone's a winner on this side, it helps to mitigate that being an issue.
Yes, yeah, it does. And it gives the parties both an opportunity, one, the costs each party incur with their own legal practitioners really come into highlight then, and you can really assess where the level should be and what's an appropriate amount to be paying for the losing party. And so again, it's important to remember the alternative. If you're unsuccessful in any part of your defence of any claim, you may be required to pay the other party's legal costs. Now, one way of really reducing that risk as well is engaging in negotiations, is engaging in offers, putting those forth to the parties. If the court can see and is aware, maybe at the end of the dispute, once they've determined who's successful or not, that there has been a progress of people putting offers, reasonable offers, then they may reduce that likelihood of paying those costs. But if litigation takes place in a tribunal, and this is an important point, now each state has tribunals. In Victoria, ours is VCAT, so that's the Victorian Civil and Administrative Tribunal. Tribunals are usually no-cost jurisdiction, which means that they are the tribunal is unlikely to make an order that the opposing party pay some of your legal costs or that you'd have to pay them. There are circumstances, but it's more unlikely in a tribunal setting as opposed to a court setting.
So in a tribunal setting, more often than not, you're paying for your own costs. Each side are paying for their own costs.
Yes.
And there's no
Yes, it's an equal. Yes. Yeah, equal. It would only be if there were usually if there are more complex circumstances, if there's been some maybe unreasonable conduct for either party, that the tribunal may then order some costs are payable, but it is more unlikely in that scenario.
Mm-hmm.
So I really hope what I've said today, Julie, helps debunk some of the myths around this. It's an area that I'm incredibly passionate about. I love guiding my clients through this process and providing them with that resolution at the end, whether it is early stage, whether it's through the court or tribunal process. And with that, I've experienced all the Victorian jurisdictions, the federal court, and also the High Court, which was a really successful case for our client. So do you have any other questions at all?
Well, it really highlights, I've got a question about discovery for a start, but also it's such a emotional space that people come from with this. And what are your thoughts if I say it's just no place for the emotions? Because if the emotions are directing your decision whether to go to litigation or not, and then how far to push things, then it can be the thing that ends up costing you time, energy, money, stress, where from a very realistic legal perspective, you never had the greatest chance of winning, and you end up, you're stabbing yourself in the foot from word go because you are being driven by your emotions. How do you manage that from your perspective?
It's really about that early advice and getting it at that stage. I find when we have clients that come to us who have perhaps already been in some litigation process, it's really difficult to then change their way of thinking, I think, and how to approach the dispute. I love to get in front of clients at an early stage when they're having a dispute. They may not need to go to litigation. We may be able to resolve the dispute for them, and I think that's really important to remember, is that they may not necessarily need to proceed to litigation. It can be an advantage in some circumstances. It's a strategy decision, but clients do need to be quite commercial about their thinking and really weighing up this advantages and disadvantages in their mind, and that's where we can help. That's definitely where we've seen these disputes. We know the process through the courts, but it's that advising clients on the advantages and disadvantages to them in their particular dispute, which can differ so much, as we've talked about.
Yeah, because when we're looking at somebody that has wronged us, they've done us wrong, we want them to pay for it. And the answer that we would personally come up with was what would need to happen for it to be a successful result in your eyes. That could be wildly different from what a legal version of what justice is in that particular situation.
And what a judge might order, which is very worrying.
Have you seen that judges, it's very difficult to predict where a judge might go? Can sometimes the judgments be, man, what happened there?
Sometimes. I think that really depends on the type of dispute. We often see new cases coming through, particularly when the High Court comments on things. There's been a lot, I'm sure your clients are aware of this, about the employee and contractor, and I know that we've previously had a podcast on that, and that was all based around this High Court decision that's come out, and that did surprise a lot of people. So there can be different perspectives on that, and then other matters I've seen where we've given advice to the client at a very early stage, continued in that advice through different courts in appeal stages, and it was determined successfully for our client, and it really shows them the advice that he'd been getting all along the way was correct, and what was also what a judge would think. So that was is really nice to see, but it can differ. It can.
Yeah. Going back to my question on discovery. So you were saying this is where, whether it plays well for you or not, it is your responsibility to offer up all documentation in discovery. What happens if you don't, and it's found out that you don't?
There can be a lot of consequences for that if anything comes out at a later stage. It is an obligation of parties. It's an ongoing obligation. It's not just limited to the court making an order for discovery. It's an ongoing obligation from the start of a proceeding that all of those documents must be produced. There are also consequences if there's found out there's been document destruction, for example. So it's a really important area where those documents need to be considered, because there's a real consideration as to what those documents are. There needs to be an assessment as to whether they are relevant or not to the issues in a dispute, and then their disclosure to the other parties as well.
Yeah. So we've got no guarantees at all going down the path of litigation. We've got all the chances leading up to the courtroom steps to be able to resolve any kind of disputes. Let's go back one step even further. And how can we avoid disputes to start off with? I imagine that this is where things come back down to talk out of your mouth. This is what I sometimes say to clients. Get out of your mouth all the things that are going on in the back of your brain that you're afraid of bringing up in case it makes things not go your way. For example, when, what's a good analogy? Okay, so just say I've got a dental practice. I've got a new dentist that's coming in for an interview, and I really want them ideally to work 4 days a week, but I know this person has only said that they're available 3 days a week. And so I continue on with these discussions. Yep, 3 days a week, 3 days a week, 3 days a week, without calling for the fourth day. Then when they start and they're still in the honeymoon period and I say, can you do the fourth day? They go, sure. It doesn't really suit them very well, but at least I got my way. So I've planned it all beautifully, this path of discussion where I've manipulated this person with all, good intentions for the business, and, they're going to benefit too as well as me. It's all good. But in essence, what I've done is played outside what that person truly wants to do. And I haven't been brave enough to ask the question, only if you're really happy, are you really happy moving forward with that fourth day? And because it's been my experience when I owned my practice and then working with other practices, that unless you are having that clear path of real discussion, finding out what's good for them, asking all those difficult questions, which may end up resulting in things not quite working out well for you, they don't go away, these issues. They always end up cropping up a bit later on. And so the more open and honest and clear about where you stand and creating the environment for the other person to be as free and frank as possible with their discussions and thoughts as well, only then can we really try to avoid any possible disagreements going forward.
That's completely true, Julie. We see so much around this miscommunication, this misunderstanding between parties that festers to the point of these disputes and this litigation because things haven't been clear. And that's where clearly recorded terms of contracts, clear discussions between parties, email trails, a very clear understanding of what's in agreement and what isn't in agreement can really assist to make sure that there are no disputes. And this is where that having these things down, having them appropriately recorded, you're trying to reduce your risk of any dispute or litigation arising in the future.
Yeah, and when you're setting out those parameters and having those discussions, I mean, for us, we've got a contract, and whatever's listed in that contract is the agreement that both parties have. But outside of that, there are also other discussions as well. And when you can start to summarise all those discussions that are pertinent to the arrangements that you've got with each other or the agreements that you've got with each other via email, I think that's a great step as well, because we remember our reality of the situation.
Yes,
which isn't always what the same as the other person's reality of the situation. So if you can get these sort of things in a summary email that you send out later on, the other person gets to read your version in essence, and they go, no, that's not the discussion that I had with you. So let's clarify this right now.
Yeah, it is that recording of file notes as well. Very important, very important. People often remember things differently for various reasons. And then, if we think about if we were then in a dispute 3 years down the track, 5 years down the track, how do you remember what was discussed? How do you remember that? And there is a real issue with witnesses and being able to recall facts, and it's something that needs to be considered as to what was recalled and what you have. The more you have in documents, the more emails, the more recording of any terms, any conversation can really assist.
Yeah, and I think there's another scenario that's come up in my head as well, because even with the contract, there can still be dispute around that as well. And the example I've got in my head is when a dental practice is employing a dental assistant, for example, and they're also open on a Saturday. And there is one of the particular contracts that are being used is there is a regular rate of pay that you get paid above award for Monday through to Friday. But if we added on all the penalties on that for your Saturdays, that would be unaffordable. And so rather than reduce your rate through the week, we're going to have a separate Saturday rate, which is all still legal, and you're still better off under this contract than you would be under the Fair Work Award. And so it's all still above board. But having that person that employee who isn't usually, and most people aren't really well versed in reading contracts and understanding what everything means. And so going through those sort of things together, I have found is very beneficial, because sometimes we can be forgiven for sitting back and saying, well, it's in the contract. I sent it out to them. It was their responsibility to read it, absolutely true and correct. And if they sign it, they are responsible for having signed that document and agreeing to everything within it, absolutely reasonable. However, when we're talking about avoiding future disputes and avoiding future upset that could lead to a dispute, then it is in our interests to sit down with that employee and say, this is an area that a lot of people get wrong, or don't read properly, or don't understand when they're reading it. This is what it means to us. Are you clear on that now? Are you happy to sign down the bottom? And to really open that discussion up.
Of course. And another comment is that, it's a standard agreement.
Yeah.
So there's no option to change it. Yes, just standard. It's just standard. These are just normal conditions.
Yeah.
And no, parties should be thinking about their own individual circumstances, how that would apply to them personally moving forward, and whether or not they're happy with that. And you'll often see now, Julie, in a lot of different contracts and agreements, it'll say that the parties have received their own independent legal advice, or they've received other advice, and that they agree to the terms. And it's so important that parties are considering each of the terms, looking at how it works for them personally, making those inquiries if they're not confident with it.
Yeah. Because just because the contract is in place doesn't mean that other person won't come at you with a dispute and try to dispute it, because they'll be coming from this position of, this is not what we agreed upon. This is not what I was led to understand. And so whether they recognise they can be bound by that contract or not, they can still push forward, which means you are then in that position of a dispute. And so that's what it's all about, isn't it? Reducing the risk down, not of just you getting upset with another person, but of them getting upset with you and taking things further, complicating life when it doesn't need to be complicated.
Yes, of course. Yeah, that's exactly true.
Well, this has been such an enlightening discussion, Rosie. Thank you so much. And so much of business life is recognizing where you can succeed and taking every advantage of those opportunities as possible, but then also looking at all the things that can detract from that success and reducing the occurrence, the risk of those things actually happening. And so there's a lot that dental practice owners and managers can do to reduce the chances of any patient or any employee in developing a dispute with you. And a lot of it just comes back down to clarity of discussion and respecting the world from their perspective as well. And, everyone wants to win in this life, don't they?
Yes, they do. Yes, thank you so much, Julie. That's you hit the nail on the head. That was it was a great discussion. It's a very interesting area. There's a lot to think about for your listeners in terms of how to manage their practices and just to be careful of and consider moving forward.
Lovely. Yet again, Rosie, you've been a delight, and I really do appreciate your firm's advice to the dental community, and I'm sure they are all very appreciative as well. I look forward to seeing you next time.
Thanks so much, Julie.
Hey, if you enjoyed listening to this episode, you should join the club. The club members receive an online lunch and learn twice a month where I share insights, systems and strategies to improve the success of your practice. These lunch and learns could not be easier to train your dental team. They are recordings so you can watch them at a time that suits you. For example, during team lunchtimes, pay your team members for their lunch hour. The first half hour, they're eating and watching the presentation. The second half hour, they're discussing how to implement this particular insight into your dental practice operations. And remember my favourite quote, it's by Archilochus, and he states, "We do not rise to the level of our expectations, but fall to the level of our training." So join the club now and start upskilling your team members and improving the operations of your dental practice. I hope to see you there.